the Aruj and Ayush podcast show.
Hello everyone, welcome to A Square
Aruj.
and Ayush podcast. Today, in our episode, we have students from one of the top and prestigious institute of India, that is from Indian Institute of Management, Rohtak. We have Advait, Tejas,
So we have Kisle and Naman.
In our podcast, we will be discussing Chapter 4 of Indian Contract Act 1872, that is Performance of Contract.
So Tejas, now can you please tell us what is performance of contract and what is its significance in the Contract Act?
Okay, now I will explain what is performance of a contract. Performance of a contract refers to the fulfillment of the contractual obligations by the parties involved. This means that each party must do what they promise to do under the terms of the contract. It establishes the legal duty of the parties to fulfill their contractual obligations.
So let's start with section 37. So Naman, can you explain this?
So, as we know, Section 37 is the first section of our Chapter 4 of Performance of Contract. So, Section 37 is the obligation of parties to contract. So, as we know, in a contract there are two parties, and the two parties that are involved have to do what they are agreed upon. This applies unless there is a reason. They don't have to, like a law saying otherwise. If someone dies before doing their part, their representatives are usually stuck with the promise and they have to fulfill the promise that they agreed upon in the agreement.
Now let's move on to the next section, which is section 38, effect of refusal to accept offer of performance. Here the promisor must offer to perform his obligation under the contract to the promisee, and this offering is often called tender of performance. Now there are various conditions which the offer must fulfill. The few of them include that it must be unconditional, it must be made at a proper time and place, and under such circumstances that the person to whom it is made may have a reasonable opportunity of ascertaining that the person to whom it is made is able and willing there and to do the whole of what he is bound by his performance to do. Now furthermore, if the offer is to deliver any product then to the promisee must have a reasonable opportunity of seeing that the thing offered is the thing which the promisor is bound by his promisee to deliver. In short, this means that the promisee must have sufficient time to fulfill or satisfy that the goods provided are up to the mark. Furthermore, an offer must to one of several joint promisees has several legal consequences as an offer to all of them. So an offer to one of the person is similar to the offer to all of them if the offer is joint.
Right.
So now we'll look into this section 39, effect of refusal of party to perform promise wholly. So when a party to a contract has refused to perform or has disabled himself from performing his promise in its entirety, the promisee may put an end to his contract unless has signified by words or by conduct his acquiescence to its continuation.
Now we'll be discussing by whom contracts must be performed. So according to section 40, if contracts is of the kind which is based on personal confidence or involves the exercise of personal skills, it must be performed by the promisor himself.
Right.
Also, according to Section 41, if the promisee accepts the performance from a third party, it cannot enforce it against the promisor. Kisle, would you like to give an illustration of this section for better understanding?
Yeah,
of
why not? Let's suppose that we both are in a contract where I need to give you an ice cream. Now, I asked Advait to give you an ice cream and he comes and offers you the ice cream saying that this is from Kisle and you accept that ice cream. Now you are not, I am not liable to give you another ice cream, or you can't enforce me to give you an ice cream because you have already accepted an ice cream from me.
That's a really nice one, Kisle. I appreciate it. Now, we'll move on to the next section. The next section is the 43rd section of Indian Contract Act, which is titled as any one of joint promisers may be compelled to perform, which means if two or more people make a promise together, which is called a joint promise as we know, the person they promise to, which is the promisee, can generally pick just one of them to complete the entire promise. Those who promise together can make each other contribute fairly to fulfilling the promise unless the contract says otherwise. And if someone doesn't contribute their fair share, the others have to cover it, but you can split that extra cost among themselves equally.
Now that Naman has started the topic of joint promises,
Yeah.
let's move on to section 44, which talks about effect of release of one joint promiser. So here, when two or more persons have made a joint promise, a release of one such joint promiser by the promisee does not discharge the other joint promiser or promisers, neither does it free the joint promisers, so release, from responsibility to other joint promiser or promisers.
So now we'll look into section 45, devolution of joint rights. So this is similar to section 42, but the slight change here is that when a person has made a promise to two or more persons jointly, the right to claim performance rests in between him and them, with them during their joint lives and after the death of any of them, with the representative of such deceased person jointly with the survivor or the survivors, and after the death of last survivor with the representative of all jointly.
So far, we have discussed contracts which must be performed and by whom contracts must be performed. Now we'll be delving into the time and place for the performance. So section 46 tells that where by the contract a promiser is to perform his promise without application, that is without request or without intimation by the promise, and no time for performance is specified, then the engagement must be performed within a reasonable time. And a reasonable time is a question of fact that differs in each particular case.
Correct.
According to section 47, when the performance of a promise is to be made on a certain date without the application by the promisee, then the performance should be made at usual business hours.
Now let's see the section 48. In section 48, if in the application specific date has been given, then the performance of the promise must be done at that date, but a proper time and a place also. For example, in the parcel room at a Ram Rohtak, if a delivery has to be done on 10th May, then the proper time will be between 9 a.m. and 9 p.m. Why is that? Because that is the working hours of the parcel room.
That's very insightful, Tejas.
Yeah, great explanation. So now we move on to section 49. Section 49 says that if a contract doesn't say where something should be done or performed, the person who performs, which means the promisers, need to ask the promisee for a reasonable place to do it, and then they have to do it there.
So now we'll talk about section 52, order of performance of reciprocal promises. So where the order in which reciprocal promises are to be performed expressively fixed by the contract, they shall be performed in that order. And where the order is not expressly fixed by the contract, they shall be performed in that order which the nature of transaction requires.
So now section 53 talks about the liability of party preventing event on which the contract is to take effect. So I'll explain this section through one example. Imagine Aruj and Tejas entered into a contract where Tejas promises to paint Aruj's house. In exchange, Aruj promises rupees 10,000 and clear the furniture of the house before Tejas begins. However, when Tejas starts painting, he finds that Aruj has not cleared the furniture as promised and does not accede to his request too. So in this case, Tejas can void the contract and claim the money since Aruj obstructed him from performing his promise.
So let's move on to section 54. But this section is slightly complicated, which my friend Ayush won't be able to understand.
Yes, you're right. Aruj.
So, Mr. Kamal, would you please give an example so that Ayush can understand?
Sure.
Professor Naman,
Sure. I'll try my best to give an example and explain this section to you. So, for example, you and I are in a contract where I dispatch my cargo to you and you take the cargo to South Africa, for example, we take a country, South Africa. So, in this contract, I have to dispatch my cargo to you and then you will be performing your part of contract where you will be dispatching the cargo through ship to South Africa.
Yes.
So, if I never provide you with the cargo in the first place, you won't be able to complete your part of contract and you won't be able to dispatch the cargo to South Africa. So this means I cannot sue you for your non-performance of contract.
That's a very good example, Naman.
Thank you.
yeah, that's a very good example.
Furthermore, is it possible that he can sue you for damages of him bringing his ship to deliver the cargo?
Yeah, that's right. He can obviously sue me because he is bearing his losses of the fuel of the ship and all that other losses that he incurs.
So basically, you have to compensate me for my loss.
Yeah, because I didn't perform my part of the contract in the first place.
So now, moving on, let's move to the next section. The next section is section 55. It talks about the effect of failure to perform at a fixed time in a contract in which time is essential. If the time is essential to a contract and the performance does not happen at the specified time, then the contract becomes voidable. But if time is not the essence of a contract, then the contract is not voidable, but compensation can still be recovered. If acceptance of a performance at a time other than that agreed upon, then the promisor cannot claim compensation unless at the time of acceptance he gives a notice of his intention to do so.
Tejas, adding to your points, there are three situations under which time is generally considered to be the essence of the contract. First, where parties have expressly agreed to treat time as essence of the contract. Second, where delay operates as an injury. And third, where nature and necessity of the contract requires it to be so construed.
Well explained, Ayush.
Thank you, Naman.
So now we move on to the next section, section 56, which is titled as Agreement to Do an Impossible Act. As we know, an agreement to do something that's completely impossible can't be a valid contract, which is, we can say, common sense too. If something becomes impossible or illegal after a contract is made, the contract is no longer binding on that part and can be declared as void. But if someone promised to do something they knew was impossible or illegal, they might have to compensate the other person for any loss caused by not doing it.
Talk about bringing moon to your girlfriend.
So now we'll talk about section 58, which is alternative promise, one branch being illegal. So in the case of an alternative promise, one branch of which is legal and the other illegal, the legal branch alone can be enforced. And simple illustration would be, let's consider Tejas and Kisle. So they both agree that Kisle will pay Tejas 5,000 rupees, for which Tejas shall afterwards deliver him 1 kg of rice or 1 kg of smuggled opium. So here in this case, the valid contract to deliver rice is the legal one, whereas the opium one is the void one.
Very good illustration as well.
Very nice illustration as well. Do you think I'm a smuggler?
A little bit. We have understood much about the performance of contract, time and place for performance. So now we'll start with a discussion of the appropriation of payments. Imagine you owe your friend money for a few things like rupees 200 for pizza, 1000 for concert tickets and 10,000 for borrowing a car.
Like I lose a lot of money.
So when you pay them back, you can specify which debt you are paying off. This says that if you hand your friend money and clearly say this is for the car rental, they have to use that money to pay back off the car debt, not the pizza or the tickets money. Even if you don't explicitly say which debt, it might be clear from the circumstances. For example, if you hand them a receipt for the car rental along with the cash, that implies the payment is for the car. Here's the key. Your friend can't just decide to use the money for whichever debt they prefer if you tell them which one you want to pay them off. They have to respect your wishes. This is clearly explained in section 59.
Now, we'll move on to section 62, which comprises of three important elements. The first one is novation. Novation is basically when a set of new promises replaces an old contract which forms a new contract. This is called novation. So now I will cover the second aspect, which is rescission. Rescission means termination of contract, which can be done by any party involved in the contract.
So now the third part of this section is alteration. As we all know, we all have to subscribe to one or another streaming services like Spotify or YouTube, and we all agree to their terms and conditions without even looking at them. So whenever they update their terms and conditions, this is called alteration. Like changing their old promises to the new promises.
Also, even in case of alteration, the original contract continues to be the basis of the obligatory relationship between the parties.
Just like in the recent update where the Spotify stated that the lyrics are now only available for the premium members, right?
Oh yes.
Oh yes, yes.
Good example.
Good example.
So, ladies and gentlemen, that's all for today's episode. We'll be back with another informative episode.
Thank you for watching.